John Kuntz. So Megan was telling me you were the Joker, but my mom told us a joke over Thanksgiving. Why why didn't the turkey eat? Yes. Yeah, we love that one.
Your mom, me, same wavelength.
You guys are the same wavelength. My mom would say, like, where's John? Bring him here now.
That's funny. How's she doing?
Oh, she's doing great.
Good.
We had a good time. It's always great to go back and see family.
Were you there all week?
Yes. Oh, we're getting, oh,
Are you getting money back?
So I just filed. And then after once I was done. I want to make sure that. Yeah.
Jason, on Nathan Martinez, have you all already done acknowledgements of discovery on that?
No.
Okay, all right.
I mean,
If you can have,
is she coming back tomorrow or?
Yes.
Okay, I'll get one done and have it ready,
all right,
because it's capital murder, and several other cases too.
yes.
Okay.
All right. And the capital murder case, I don't know any facts of the case. That's not definitely correct?
No.
Okay, all right, thank you.
Thanks, Stephanie.
Yeah. I will.
John, do you practice in federal still? All right, just one second. Samantha Malik or Malik?
Ready.
So let me see. All right. Dave, did you have an opportunity to tender an offer?
No, you're not.
Why not?
Because one is not requested no for another, she is going to request competency evaluation. And so.
All right, so state,
This is the one we just got the records back, Judge. It was the one where she was ED'd on the day of the arrest
Mhm.
and we got the records back for the ED and the CPS and I was just able to review those. So I filed, I anticipated that I would need to, but I wanted to review those first. So I filed, because before we make any decisions, I think that that's going to be a necessary step. And then I'll be able to confer with her to decide whether or not we pursue any type of sanity or we talk to the state about a plea bargain, which direction, once I make sure that she is competent.
and is she going through competency through
I'm
doctors?
requesting,
Are you hiring someone?
no, I'm just requesting it through the state.
All right. So Norma, if you can let them know that a competency evaluation needs to be done, you state you need to tender an offer today, and then we'll see what the competency says.
Okay,
All right. And I need an acknowledgement of discovery.
I can do that, Judge.
All right. So Norma,
Yes, sir.
let's set this for, they should probably get the competency done this month, or at least set up. Let's set this for the end of January. Let's put it on January 27th.
Yes.
Okay. Yes. Okay, just one second.
Yes.
So state Mark Ivy, he's still in federal custody. So I'm being told sentencing is February 5th. So we'll bring it back at the end of February. Norma, if you put Mark Ivy for, let's do him for February 27th. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court can find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,500 fine. The state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 180 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
And in exhibit 1 and attachments, Your Honor.
No
Any-
objection.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations of testimony and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I've spoken to the state about addressing the fine and community service. My client has a special needs client, or a special needs child who's 7 years old, autism, nonverbal. And that takes up a significant amount of her time. She also has a 3-year-old who's in the Head Start program. And she owns a small business where she does baking. We would like any help we can have on the fine and community service, Your Honor, considering the demands of her time with her child.
All right, why were you driving 80 miles per hour?
I wasn't driving.
Oh, no.
No.
Oh, somebody, I mean, if somebody else is driving, because they're saying you were evading in a vehicle. So if you want a jury trial, we'll give you a jury trial. State? She says she wasn't driving. Part of evading arrest, detention in a vehicle is you're the driver. According to the police report, it states that she was driving.
Yes, Judge, we also have a dash cam video of it, of her getting out of the driver's seat.
All right. They say there's a dash cam video of you getting out of the driver's seat.
I was just a bit angry that night.
Then why are you pretending as though you were not driving?
I'm nervous.
No, nervousness doesn't make you be dishonest. You told me that you were not driving. And now the state says they have a dash cam video of you actually getting out of the driver's seat.
Mhm.
So why were you driving 80 miles per hour?
I was just on edge that night and I
Why?
was trying to get home.
Why?
Me and my boyfriend at the time were fighting.
And is this Eduardo Ramirez?
Yes.
All right, so what time of the night was this?
I don't really remember, to be honest with you. I really don't remember.
Was it dark outside?
It was. It was dark.
All right. Were your children in the vehicle with you?
No, ma'am.
So who was taking care of your children?
My parents.
All right, so Now we know the real people who are taking care of the children are her parents. She's just still living her best life with her new boyfriend.
That's not true.
Okay. So you're evading 80 miles per hour in a vehicle. Your attorney says you have a special needs child because plus you have a young child and you're out for a joyride with Eduardo Ramirez. And you're speeding going 80 miles per hour in a 40-mile-per-hour zone. So I think counsel, she has time to do the community service because I think her parents are doing more than what's being presented to me. So do your parents babysit
Sometimes, yes.
while you're running your bakery? Where are you running your bakery from?
At home.
All right, that's your house, not their house?
It's their house.
All right, so her parents are doing the heavy lifting. All right, it's going to be a $1,500 fine. That's going to be probated. 4 years deferred adjudication, 180 hours of community service restitution. I'm going to order parenting classes. Once she completes parenting classes, community service hours will be deemed satisfied. So do you have all of your DBAs in order, or you're just baking from your home and when people want a cake or,
No, it's registered with the county.
all right.
Mhm.
There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. If you're drug tested today, what will the results be?
Negative.
There's going to be field visits 1 time per month for 6 months, defensive driving course. And there's to be no contact with Eduardo Ramirez.
The only issue with that is that as of now is her husband. I believe they're going through a divorce, but there might be the need for contact to resolve that divorce.
All right, no contact with Eduardo Ramirez. The only exception is for court.
That works.
Is
Thank
there
you, Judge.
anything else?
Nothing further, Your Honor.
Probation, is there anything else she needs?
No, no, no.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Your children have to come first. Going well, not always, because you would not have been going 80 miles per hour, whether you're upset with your boyfriend / husband or not, because anybody could have been killed. And police don't like when you're going 80 miles per hour, they tell you to pull over and you don't.
Mhm.
You could have just been another person on the news that's dead with your parents doing a GoFundMe for your children. You have to put your children first. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Omero Sanchez. Court is calling 2024 CR 008247 State versus Omero Sanchez. Can I have parties announced for the record for the state? Defense,
David McLean for the defense.
are you Mr. Sanchez?
Yes, Your
Counsel, have you received all of the discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sanchez, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes,
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
Did you review the court admonishments and defendant's waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine.
Yes, Your Honor.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, Your
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
None.
Anyone promised you anything other than the plea?
None.
Satisfied with the way you've been represented?
Yes, Your
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 5 years in the prison. The state is silent. There's $1,000 fine, affirmative finding of deadly weapon. The state will be silent on your application for deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with the complainants and no contact. Are you all asking that he be allowed contact about the children through a third party?
Yes, Your Honor. The second person there on the no contact is the mother of his children, and we're asking, the agreement is that he'd be able to contact her about the children through a third party. Something like AppClose or some other portal.
So you're not allowed to contact any of the complainants. You are allowed to contact, the only exception is you are allowed to contact one of the complainants through a third party, and the subject matter has to be about the children. Do you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor, and Ashley Jones.
Thank you. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
And did you understand with an affirmative finding of family violence, you're not allowed it to be designated as primary custodial parent?
Yes, Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plea?
No.
State any evidence.
Yes, Your Honor, state will offer State's Exhibit 1 and all attached.
Your Honor, I reviewed that with my client. We have no objection.
All right, state, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. So are you requesting a PSI?
Judge, given that the state's silent, we probably need one. I'd waive it if the court would consider giving it a deferred today. But I know the judge probably
Well,
doesn't have enough information to do that.
I do not. So we can, if you want, it's probably going to be about 8 weeks. That's how long it's taking for the PSI. Or if you want this heard before the end of the year, then I can reset it for the week of December 16th. And you can bring in whatever witnesses you would like to bring in. But if you want the PSI, I'll give you the PSI.
Let's do the PSI, Judge.
All right. Norm, I need a PSI and TAP evaluation. State, it's a PSI and TAP evaluation on Sanchez. And also do a MIC evaluation. What date? All right, we'll come back on January 21st.
Judge, that is a Tuesday. Is there
Okay.
any way we could do any other day?
All right, the 23rd.
23rd is fine. Thank you, Your Honor.
All right, we'll see you back on January 23rd. I'll make my decision based upon whatever evidence that's presented.
Thank you.
All right, thank you.
Thank you, Judge. Appreciate it.
Welcome. AG. And who's your client? Yes. All right, just have them pull the file. AG, Byron AG.
Present.
All right, counsel.
Judge, Mr. Ag was just determined to be competent on
Okay.
November the 21st. We received an offer from the state. I need some additional time to explain the offer to Mr. Ag slowly so that he understands.
All right, when would you like this brought back?
I'll judge whatever you deem appropriate. I do have a vacation letter on file from December 16th to the 1st of the year.
Well, do you want to bring it back the week of December 9th?
That's fine, Judge.
All right, what date? 9th, 10th, or 12th?
12th, Your Honor.
All right, Norma, if you recall this back for December 12th for a plea deadline date. All right, thank you.
Thank you, Judge.
Thank you. Jesse Vega. Good afternoon. Hi. All right, what's happening with this case?
He's coming up.
No, we've conferred with Mr. Garahan. He's made an offer that we really like. Heard of my client, or he wants time to confer with his mother and father about it. We could recall this case next Monday.
Okay, how old are you, sir?
37, 38.
All right, see, this is what I always tell teenagers. I tell them the time to confer with your parents is before you make decisions. Like, for example, if somebody wants to invite you to a party and you know there are going to be drugs there or there's going to be drinking, you need to go to your parents before you go to that party, as opposed to after you get to the party and you get arrested. Mom, let me see what's going on. You understand? So this is the last time that this is being set for disposition. This is going to be your final plea deadline date. After that, it's going to jury trial. You understand? All right, so we're bringing this back on December 9th.
Judge, thank you very much
Thank
for
you.
consideration. Have a
All right,
good
thank
day.
you. Norma, Jesse Vega, December 9th. All right. Raul Juarez. We're back on the record in 2021 CR 8180 State versus Raul Juarez. Can I have parties re-announce for the record? State
Christian Vega for Mr. Juarez.
and you're Mr. Juarez.
Yes, ma'am.
And my understanding, both parties had a chance to review things and you all have reached a stipulation. Is that correct?
That is correct, Your Honor.
And what is the stipulation?
The complainant, we spoke to the complainant and she said that she did not live at the address. She was there to pick up Mr. Juarez to go to Corpus Christi. They went to go see his family, came back, dropped him off, and that is when everything happened. But that she was welcome in his house.
All right, and she was aware that there was a no contact order?
Yes, Your Honor.
And there was no contact before that day. It was just, she wanted to drop off a gift to the granddaughter, so they met, they took the trip.
That's correct.
All right, are you available to come back tomorrow, counsel?
I should be, Judge.
All right, this is something that I need to think on.
Okay.
All right, because I will tell you, we can go off the record. This is my issue. One, he behaved badly, whether he was completely intoxicated or not. I do note that he was intoxicated to the point of going to the hospital. And then we have a no contact order. And he has stated on his motion to revoke that she's the one who contacts him. And then we have an incident now where she's coming to his home, regardless of whether, you know, they were going to Corpus for family or not. You know, a no contact order is in place. So I need time to think about this and decide whether to grant his application or send him to prison. So we'll come back tomorrow.
That's fair, Judge.
All right, thank you. Norma, on Juarez, it's coming back tomorrow.
Thank you, Judge.
You're welcome.
Have a blessed day.
All right, thank you, you too. Joseph Kruger,
We're here, Judge.
yes. Yes.
Oh, we were here a couple, just from around the court. We were here a couple of weeks ago.
Oh, he wasn't transported.
Yeah, they left him at the jail.
Good afternoon. So what's happening?
We just need a trial date, Judge.
All right, Norm, I need a jury trial date on Kruger. and it's criminal trial division. It's an evading possession, fraudulent possession of identifying information and possession of a credit card.
I would think 2 to 3 days with Fort Dyer.
All right, 2 days.
Oh,
That's the date.
And the reason about it, there's just, I'm beyond words of saying my frustration of being incarcerated. So we could speed up a little faster. And I apologize for you, I hadn't seen me in orange.
Oh, no problem. No, here's the thing. This is what I can tell you. In this court, we try cases. We try a lot of cases. The first time that you've been on docket in this court is November 2024. So the fact that we're not going to be able to try your case till January, I know it's a lot of time because you're in custody. Every day is a lot of time. I always tell people 1 hour is a lot of time in custody. I try to move cases as quickly as possible, but making sure that due process is recognized. Thank you. So the earliest we can bring you back is January.
The credit card was like from March, April, and then I got these other charges on.
Well, no. What I'm telling you is, I know that you'll have a case, and what will end up happening when you have a case is that you get taken into custody. And those days that you're in custody, I don't necessarily see you. I only get you once the case is indicted or if your attorney wants to have you brought over. That's the only time I see you. All right, Norma, what date? All right, January 21st, and I'll make sure that you go.
Thank you, ma'am.
All right, thank
Every
you.
day. See you.
Great, you too. Thank you so much. Ayana Hubbard. Yes, come down. Hello.
Morning, Judge.
Hello, how are you doing?
Good, how are you doing?
Oh, I'm doing okay. So where are we?
We are back on a status, Judge. We are awaiting an incompetency or incompetency report. It is in as of, I believe the 29th or so. It's sealed to me right now, so I haven't been able to see it.
Oh, just 1 second. We're gonna get that for you. Norma,
Oh.
can you see if they can email you the competency evaluation?
Ayana Hubbard.
Ayana Hubbard.
I don't know if it'll be sealed for you. It said Laura Castillo on it, which I thought.
All right, we're gonna make sure we get this for your attorney.
And I emailed Angela Martinez with Judge Carruthers Court to say, hey, I saw the report come in, if you wouldn't mind giving us a
All
date.
right, so what we're gonna do, Norma, we're gonna recall this for December 16th. They're gonna get the report to you today. And if it's an agreed competency, you all agree, we'll put it down there very quickly and then bring you back up here.
Okay.
All right, so we're gonna bring you back on December 16th, okay?
Okay.
All right, thank you.
All right. May I be excused?
Yes.
Thank you.
Oh, just 1 second. Norma's gonna get that for you so you can have it. All right, Deputy Laura. We can clear the box because we're bringing the jury in.
For who, Judge?
Because Collins. Collins, who is your client?
It's in.
Casanova?
Casanova. Yes.
Okay.
So
Aguilar?
everyone else who's been called back at 1:30, I'm gonna have you all wait
Johnson?
in the hallway. Let's see
You guys still here?
if this jury is actually going.
Oh, maybe.
Casanova?
So Ms. Johnson,
She'll send it to me too, when she sends the data, right? She always includes them. Thank you.
all right, hi, if you just have your client, if you all can wait outside and we'll see if this is actually going.
Yeah.
Yes, yes.
I think we have an agreement on in limine, Your Honor, that I'll present to the judge. Also, my client is requesting to be able to change his election punishment from the jury to the court. Your Honor, in light of his now considering probation.
Mhm.
And the other thing,
We also want to put the offer on the
Yes.
record with him present.
All right, so let me step out of the way.
thank you.
All right, yes. We're on the record in 2024 CR 007360002, State versus Richard Casanova. Could I have parties announced for the record for the state? Defense? And Mr. Casanova, if you could come up, please. All right, you're Mr. Casanova? All right. So defense, there's something you wanted to place on the record?
Of course, asking to change our election from punishment from the jury to court. Your Honor.
All right, and Mr. Casanova, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, Mr. Casanova, you understand you have a right to have a jury deliver punishment if you were found guilty? If you were to be found guilty, you know you can have the jury complete the punishment phase. And so are you asking not to have the jury do that if you were found guilty and to come to the court? Okay. All right, and then next counsel?
No, we haven't agreed. We fortunately are.
All right, and are you in agreement, defense?
However, I do want to point out that I am going to be mentioning what the indictment is alleging, which is to prior convictions in charge. I'm not going to mention any of the people facts because just conviction, and also precedence of a violation for the case. I will mention that order. I anticipate that to be an item of evidence, and the protective order does mention that a court found that family violence was committed. I'm not planning on introducing any details as to what family violence will constitute, but the fact that there is the language, that's the only thing that I'm going to go into.
I'm aware, Your Honor, if it comes up to the point where it's fought any other time, I'm not waiving my right to look it out.
Okay. All right, is there anything else? All right, then, with regards to the motion in limine, counsel just approached and the court is aware and the defense is aware, and I'm sure Mr. Casanova through his counsel is aware that the mention of the prior violation of bond or protective order are jurisdictional. All right, is there anything else? All right, so each side will have 20 minutes. We will bring the jurors in.
Ready, Mitch?
Yes.
All right, jury.
Thank you.
Right over here. Yeah, the line is ready. Break over here.
Yeah.
All right, everyone, please be seated. All right, everyone. Sorry about the late start for you all, but as I told you before, we were a little bit late with our lunch hour, and I'd like to make sure that the court reporter has a chance to rest her fingers before we proceed. So you all are in the 187 District Court. It's on the 4th floor, and I'm Judge Stephanie Boyd. So what floor is everyone on? All right, what's the court number? 187. Who's the judge? All right. You probably say, we know where we are. Why are you asking this of us, right? This is why I ask that. Because whenever we take a break, you all have to leave the courtroom. And I have time for us to come back. And you'd be shocked to learn that sometimes when we do that, people get lost. We've had other jurors try to go and be on another jury panel because they've been lost. So if you ever get lost and you can't remember the 4th floor, you can't remember 187. If you remember Judge Boyd, I'm the only Judge Boyd in the entire courthouse. So that's why I tell everyone that, and I ask that question. So to my left is the court reporter. I always said if I were ever in a position to make someone's job easier, I would. So I will need your help with that. The court reporter takes down everything that everyone is saying. As you can imagine, some people talk fast, some people whisper. We can't have that with the court reporter. So to make her job easier, I need everyone to use their outside voices. In your possession, you have cards with numbers on them. Those cards signify the number you are on this panel. So could everyone please raise your card for me? And don't lower them until I ask you to lower them. So jurors 1 through 21, please lower your cards. Oh, somebody has an important phone call. Please make sure your phones are on silent. All right, so to make the court reporter's job easier, if you have your number still raised, whenever you're responding to a question, I need you to stand so that the court reporter will be able to hear. I have tried many a case in the 187, and no jurors have been able to follow that instruction. So I'm going to tell you what I tell those panels, but I have faith. This is the jury that is going to follow those instructions. So you may lower your cards. The other thing, if we can make sure that we don't talk over each other. I know it's easy to get in a conversational mood where people are finishing each other's sentencings, but I'm going to ask that you not do that because again, it'll make it easier for the court reporter if you don't do that. So at this time, I'm going to have the parties introduce themselves to you for the state.
Alexandria Bogus.
Hi, everyone. My name is Raymond Saldana. Nice to meet you.
For the defense.
Good afternoon, ladies and gentlemen. My name is Michael Collins. This is my client, Richard T. Casanova.
All right, thank you. You may be seated. Of those persons who've introduced themselves to you, if there's anyone here who recognizes or knows any of those parties, please raise your card. Right, I'll take that as a no. Now, Mr. Casanova stands charged by indictment with the offense of violation of a bond or protective order with 2 previous convictions. And I'm going to come back and talk to you about that a little bit later and what that means. What I can tell you is neither the state nor the defense can tell you what they think the evidence is in this case. They are not allowed to. They are not allowed to give you what they think the facts of this case are. The only thing they will be talking to you about are hypotheticals. So when they speak to you, don't go to the back of your mind and say, oh, so this is what this case is really about. The only thing you really to know about this case is what the charge is. Does everyone understand?
Yes.
Okay. Now, what is an indictment? An indictment is just a piece of paper. and it's what's used to have a case held over for trial in felony court. It's not evidence of guilt. It's not evidence of anything. It's just a document that tells somebody what they're charged with, what they're being accused of, and where they need to be to answer for what they're being accused of. Does everyone understand? For example, let me see if we still have a lot of bad drivers in San Antonio. Raise your card if you've ever had a traffic ticket. Oh, yeah. Yeah, that's about right. I've had a traffic ticket too. So when I received my very first traffic ticket, and I'm proud to say I've only had one, I was much younger. I was about 18, 19. So that was about 2 years ago. So anyway, at that time when they would give out traffic tickets, the officer would have a paper booklet and they'd write something down and they'd hand you one and then they keep the one for their records. So let's say you get a traffic ticket and they say, we think you ran a stop sign. So they pull you over, turn on the sirens, pull you over, and they give you a ticket for running a stop sign. When you accept that ticket for running the stop sign, you're not saying, yes, officer, you're correct, I ran a stop sign. That's just you being given a piece of paper to say, I'm accusing you of running a stop sign. It would be a shame if you were to go to traffic court and you get a shock surprise and say, oh no, it's actually for a red light, because you're not prepared for that. So that's what indictments are. They're not evidence of guilt. They're not evidence of anything. And you can't take it as evidence of anything. It's just telling someone what they're charged with. Does everyone understand? Is there anyone who's going to hold it against Mr. Casanova because he's been indicted? No. Okay. Now, the other thing I want to talk to you is about the charge. I said that the charge was violation of bond or protective order with 2 previous convictions. The 2 previous convictions are what's called jurisdictional. Have you all ever heard of somebody who has a DWI third? All right, DWI third means that they'll be in a felony court, not a misdemeanor court. Now, in a case such as this, where it's a violation of bond or protective order, the state will have to prove that a violation of bond or protective order actually happened. Does everyone understand?
Yes.
And then if there were 2 prior violation of bond or protective orders, they would have to prove that as well. Does everyone understand?
Yes.
So for example, hypothetically speaking, let's say that someone has been convicted of 2 previous violation of bond or protective orders. Let's say, yes, they've been convicted of that. If they were in felony court, the state would still have to prove that there's another violation of bond or protective order. Does everyone understand? So similar, if somebody has a DWI third, the state would have to prove they had 2 previous convictions of DWI third. And you can't, as a juror, say, oh, well, you know what? They have these 2 convictions of DWI. So obviously they did this one too. That's not the way the law works. Does everyone understand?
Yes.
The way the law is that they would have to actually prove that they committed a DWI this time and then show that they had prior DWI convictions. Does everyone understand?
Yes.
So in violations of protective order, what it means is the state would actually have to prove that there were 2 prior convictions for violations of protective order. And then if they're saying there's a 3rd violation of bond or protective order, they would actually have to prove that as well. Does everyone understand?
Yes.
So you are not allowed to say, oh, well, they did it this time. So last time. So that means they did it this time. Does everyone understand?
Yes.
And everybody has a right to remain silent. What does that mean? That means that you do not have to be called to testify. You don't have to testify. It's your decision if you testify or not. I've been a defense attorney. I've been a prosecutor. Sometimes I would have a client and I would tell them the state didn't prove their case. There's no need for you to testify. Sometimes I would have a client that was so afraid of testifying, get nervous because you're speaking to a lot of people and maybe you feel as though your life is on the line or your freedom is on the line and you're just extremely nervous. And I would tell them sometimes, it's best that you not testify because you're already sweating and you're just talking to me. Sometimes people stutter. So there are many reasons why people may not want to testify. The thing of the matter is, everyone has a right to remain silent and they do not have to testify. Does everyone understand?
Yes.
So you cannot be Mrs. Kravitz from Bewitched thinking about, well, I wonder what they would have said. And I've seen plenty people who will say, well, if that were me, I would, want to testify and say what I needed to say. I always tell people it's easy to say that because it's not you. But once it's you, you're completely different. So the main thing is, if Mr. Casanova decides not to testify, you cannot hold it against him. You cannot consider it. And if you are on this jury and deliberating, you cannot bring it up whatsoever. Does everyone understand?
Yes.
Is there anyone here who cannot follow that? All right, the next thing I want to talk to you about is burden of proof. The state has the burden to prove this case beyond a reasonable doubt. What is beyond a reasonable doubt? When I was in law school, they had a definition. You had to memorize that definition. I did. I knew it backwards and forward. I still know it. I know where to put the commas. I know where to do the exclamation point. I know where to pause for dramatic effect. See how I did that? But guess what? After my first jury trial, and I was so proud of myself because I didn't stumble, there's no longer a definition for proof beyond a reasonable doubt. So I had to figure out, how do I explain it to a jury when I can't tell them because there's no definition? So this is the way I would explain it to them. Next door, we have the historic courthouse. That's the building with the green rooftop. Over there, they have civil cases. Their burdens of proof are preponderance of the evidence. That's one of them. More likely than not, something happened. If you're ever on a criminal jury and you're deliberating and you start saying, I think this happened more likely than not, you are not at the correct burden of proof and you've lowered the burden of proof. Does everyone understand?
Yes.
The other burden over there that they have, that's their highest burden, is clear and convincing evidence. Clear and convincing evidence is the type of evidence that they use when they terminate your parental rights and they say, you're not a good parent, you're a danger to your child, so legally we will not allow you to be this child's parent. That's a very high burden. Well, there's one burden that's higher than that, and that is proof beyond a reasonable doubt. The state has to prove it. The defense does not have to prove anything. And the way our professors explained it to us in law school about the burden of proof, they said, as a defense attorney, you can sit over there. You don't have to ask questions of anybody. You and your client can play tic-tac-toe. This is my time frame, my era. We play tic-tac-toe on a sheet of paper. You could do that. You can play video games. You can read Marmaduke from the newspaper. You can do all of that because you don't have to prove anything. If you're ever on a jury deliberating and you start asking yourself, I wonder why the defense didn't call this witness or why the defense didn't do that, that means that you have shifted the burden and you cannot shift the burden to the defense. Does everyone understand? Is there anyone here who cannot follow that? The next thing I want to talk to you is about presumption of innocence. Everybody who's charged with an offense is presumed to be innocent. What does that mean? That means right now, because the state has not presented any evidence, if I were to ask you if Mr. Casanova is guilty or not guilty, what should your answer be? All right, see, I'm hearing some over here, a little bit on this road, nothing from here. So if I were to ask you right now, if he were guilty or not guilty, what should your answer be?
Not guilty.
All right, see, I can hear that now. All right, so the next thing I want to talk to you about is fairness. And what does that mean? Each side wants a fair trial. So this is what fairness means. It means that whatever evidence is presented to you, if you're on the jury, if you're able to come to a decision, you will base your decision on the evidence that you hear. Sometimes counsels will say to a jury, oh, you got up this morning, you were excited about serving on a jury and you planned everything out. You knew about the one ways. So you get up, you had your morning coffee, your scrambled eggs, and you come down and you find out your car has been burglarized. But you're a great juror, so you call the police. They take pictures of the glass. You catch the Via or an Uber and you come downtown. And then you're called up for jury duty. And you come in and the judge says, all right, so the charge here is burglary of a vehicle. Then they always say, so that's not the right jury for you, would it? That's not the question. Here's the correct question. The question is, even though that has happened to you, would you be able to listen to the evidence? And if you can come to a decision, base your decision on the evidence you hear, not at the back of your mind saying, well, I think that person may have burglarized my car, so I'm just going to find him guilty. Does everyone understand?
Yes.
Because everyone realized that nobody was born yesterday and slept all last night. Everybody has issues in their life. Everybody has bad things maybe that has happened to them. So fairness just means whether or not you can listen to the evidence, and if you can, base your decision on the evidence that you hear and nothing else. Does everyone understand?
Yes.
Is there anyone here who cannot do that? All right. The next thing I want to talk to you about, there are two phases to a jury trial in Texas. First phase, people think that's the innocence phase, but really it's not. The first phase is, did the state prove their case or not? If they prove their case, then that means it's guilty. If they didn't prove their case, then that means it's not guilty. That's all the first phase is. Now, if you find somebody not guilty, there's no phase two, because phase two is the punishment phase. If you find someone guilty, punishment phase. Everyone who's charged with an offense has a right to decide if they were found guilty, do they want a jury to give punishment or do they want the court to give punishment? That's a defendant's right. Does everyone understand?
Yes.
In this case, Mr. Casanova has decided if he were found guilty, he would like for the court to give punishment. Is there anyone here who's saying to themselves, you know what? If I'm doing the beginning of the trial, I want to do every other part of the trial. Is there anyone who's going to hold it against Mr. Casanova that he has decided if he were found guilty, he would want to come to the court for punishment? All right. Now, the next thing I want to talk to you about is about languages. I love languages. I think they're so beautiful. I ended up in undergrad school, graduate school, and law school. And the students that I was with, they spoke all these different languages. Students from the Middle East speak 6 languages minimum. I had people who were Navajo trying to teach me the Navajo language. I never knew I was going to be in Texas. I'm from Louisiana. So when they were bringing languages to our school, I figured I'd take French. My friend said, Stephanie, take Spanish with me. I looked her in the eye and I told her, I will never have a need to use Spanish. I will be retired, living my life in Paris. And so I wanted to be retired at 21 because nobody ever tells you what adulting is. And here I am 22 and I'm not in Paris. So I can tell you how to say hurry up in every language because that's what I picked up from everyone. So is there anyone here, and raise your card, if English is not your first language? And raise your card and keep them raised until I call out your number. We have 7, 9, 10, 19, 20, 45, 58, 60, and 63. All right, juror number 7, what is your first language?
Filipino.
We've had Filipino here before. So have you been able to understand everything?
Not everything, but there's a word that sometimes, I can't understand perfectly. I mean,
How long have you been in the United States?
I've been here in the United States I've been married for 31 years.
Oh, congratulations. Not many people can say that.
Thank you, ma'am. It's just that I still have the, I don't know, the,
Well, let me ask you this. Did you attend school here or no?
no, no, ma'am.
All right. All right. And how do you say hurry up in Filipino?
Oh, bilisan mo. Bilisan mo is hurry up.
All right. Thank you very much.
You're welcome.
Juror number 9. Yes, first language. Have you been able to follow along with everything? Thank you. Juror number 10. First language. Have you been able to follow everything? Thank you. Number 19.
Chinese,
I'm sorry.
Chinese.
Oh, okay. How do you say hurry up in Chinese?
快些.
Okay, I'm gonna work on that. Thank you so much. Have you been able to understand everything?
Yeah, pretty much.
All right, so what does pretty much mean?
Yeah, I can understand.
All right, thank you. Number 20. And what is your language?
Mother language is Mandarin Chinese.
Ah, Mandarin, it's different. How do you say hurry up?
快点.
All right, thank you. I like that. Have you been able to understand everything?
I have.
Thank you. Number 45.
Spanish.
Have you been able to understand everything? Thank you. Oh my gosh, my faith is restored in this jurors because you all are standing. Number 58. 58. Have you been able to understand everything?
Yeah.
All right. And did you go to school here? All right, thank you. 60.
Spanish.
And have you been able to understand everything?
Yes.
All right, thank you. 63. Ah, have you been able to understand everything? Tell me hurry up in Farsi. Thank you. All right. Now, the next thing, I expect this jury trial to last today. You all have to come back tomorrow in the afternoon. And so this jury trial will probably conclude no later than Wednesday. So as far as time constraints, travel arrangements, is there any issue for anyone with being here through Wednesday? If there is, please raise your card and we'll see what's going on. All right, 4, 9, 10, 18, 27, 33, 44, 45, 49, 57, 63, 71, and 75. Number 4, what's your issue?
I need to do a liver transplant tomorrow.
All right, so everyone, he just said he needs to do a liver transplant tomorrow. So you all, your excuses got to be up there, okay? All right. So are you performing it?
I'm the surgeon.
Okay. All right, number 9. Transplant?
No, I'm an interventional pulmonologist. I have procedures scheduled for lung cancer diagnosis.
All right, so anybody else, if you just want to not be heard on your. Number 10, I'm sorry?
That's gonna be just a Wednesday,
Yes.
it's because my sister is out of is here visiting. Nobody can take her back to Austin to leave. I need to take her to the airport.
All right. And when is she leaving for Austin? Oh. No Uber?
No.
All right. All right, thank you. Number 8, well, maybe 4 or 9 could take her. Number 18.
I have a dental appointment.
What time?
It's Wednesday at noon.
All right, thank you. Number 27.
I have a doctor's appointment first thing Wednesday morning.
All right, thank you. Number 33.
Your Honor, I have 2 outpatient procedures at Audie Murphy.
Well, I know how long it takes to get in there. When is it scheduled?
It's scheduled, the first one is scheduled for 9:15. The second is scheduled for 10 a.m. Your Honor, it does require general anesthesia.
All right, is that tomorrow?
The procedures are on Wednesday, Your Honor, but I need to begin medical preparation tomorrow.
All right, thank you.
Thank you, Your Honor.
Number 44,
I own a small business. I'm the main one that does most of the diagnosing, so this hurts my income and my business.
all right, thank you. Number 45,
It'd be a financial hardship. So I'm a landscaper and I work hourly and every day is precious. I support a family of four. If it weren't for that, I'd be happy.
all right, thank you. All right, so everyone, make sure you keep your voice up and use your outside voice, please. Number 49,
I have classes tomorrow.
all right, is that in person?
Yes.
Did you tell them downstairs you had classes in person? That's something that should be done. So what school are you at?
I'm at the state
All right, and when are your classes?
tomorrow from 11 a.m. to 3.
All right, thank you. 57,
I have a doctor's appointment at 8 a.m. on Wednesday.
thank you. 63,
I'm putting the unit on the nurse executive director of medical surgical unit in University Hospital.
all right, wait, hold on. So I already can hear the court reporters' blood pressure elevating, so slow it down a little bit, so.
I'm opening the floor and I'm hiring tomorrow at 1 to 3.
Okay, 1 to 3. And what do you do?
I'm executive director of medical surgical unit in University Hospital.
Are you with number 9, prepping for him? Ah, see, I had an idea. 71. All right, thank you. 75.
Childcare, picking up my kids.
All right, when do you pick them up?
2:30.
All right, thank you. 69.
My in-laws are out of town on a cruise. These next 2 days I have to watch my son.
Oh, I thought you were going to say your in-laws were in town, so please select me or something. They're on a cruise?
Yeah.
All right, and how old are the children?
I have a one-year-old son.
All right, 7.
I don't drive, ma'am.
I'm sorry,
I don't drive.
you don't drive?
No.
Okay, how did you get here today?
Oh, my husband dropped me off.
Okay, all right, thank you. Number 14.
I'm a dentist and I would have to reschedule.
Oh, what? I'm sorry.
A dentist tomorrow and Wednesday.
All right, so is that your patient?
No.
All right, so is there anyone here who knows someone other than you were downstairs and you stood in the hallway together? So if you know someone on the panel, please raise your card. Wait a minute, she just told me she knew you. All right, so you raise your card if you know someone. All right, 63 and number 9. All right, 63, do you know number 9?
Yes.
All right, 9, how do you know number 63?
She was in the Methodist Hospital on the 6th floor, Central. She was the director.
All right, he just verified who you are. All right, so I'm going to tell you all 2 stories. Both of these stories are true. Number 1, jury duty is an inconvenience. And I say it's an inconvenience because 1, people don't normally come downtown. People try to avoid downtown. When you get down here, there are a lot of one-ways, and you're saying to yourself, the building's right there. If I could just turn right here, I would be there. And then you probably start thinking, is there an officer around here? Because maybe I could just sneak in, there's no traffic and I just get here. Then when you finally make it to the courthouse, you don't know where you're supposed to go. Then they do the check-in, and then you look at your watch or your cell phone and you say, oh my gosh, I'm late because I was supposed to be here at 8. Then you rush at 8, and I see you all rushing. I tell everybody, you need to slow down because it's a hurry up and wait situation. Then you get downstairs and you wait. And then you get called up to the 187 at 11, and then you wait outside. And then I tell you, come back after lunch. So all of that is an inconvenience. Let me just tell you what I feel a sacrifice is. My family grew up in Grand Cane, Louisiana. And in Grand Cane, Louisiana, all of the teachers knew everybody. They knew all of their students. So my uncle was super intelligent, and the teachers would just keep passing him from grade to grade, and they would tell his mom, my grandmother, we can't teach him anything else because he's so smart. So of course, when his brother and his sisters come behind him, they don't like that because everybody knows everybody. And the teachers tell them, we're going to be expecting a lot out of you because your brother's super smart. So my uncle ends up graduating. And when he graduates, the Vietnam War breaks out. And he goes to my grandmother and he asks her to sign for him because he needs her signature because of his age. And he tells her, the way things are, there's no way I'm going to improve my lot in life, that I'm just going to have to sign up. So she signs for him to go. And that was back in a time, young people, there were no cell phones. This whole thing where you have television on that's 24 hours a day, that wasn't the case back then. My grandmother had a television set. You had the rabbit ears on it. You had 3 stations, ABC, CBS, and NBC. And NBC, the weather had to be perfect. Otherwise, you were not going to get it. No amount of tinfoil on the antennas could make it work great. And then at a certain point in time, the television would just stop playing. And either you would get the white noise. When it got high tech, they would play the national anthem and the flag would blow in the wind. And then, you know, television is over. See you tomorrow. My grandmother's phone. And I know young people may not know what a rotary is or a touch tone phone is. Her phone was not a rotary and it was not a touch tone. You just picked up the phone, an operator would answer, and you would tell them who you want. That's why they would have the songs like Beechwood 45789. That was the number. You pick up, the operator answers. So my grandmother signed for him, and there was no email. So she couldn't email and say, did you make it all right? And back in that day and time, my grandmother, super intelligent woman, she had a 6th grade education, but she taught me how to read, tell time, all of that. But the only thing she knew was he was going off to war. Nobody knew where Vietnam was. You would be glued to the television set to see what's going on. She would just write him a letter, put his name on there and his number from the military. That's it. And then you get a letter back 6 months from now. The one thing she quickly realized is that the last thing you want is somebody from the military knocking on your door, because that was not good. So my uncle did make it back, but I tell everybody that story to tell them that's what I consider a sacrifice. We always wave flags for 4th of July, Veterans Day, Memorial Day. Your government is only asking 2 things for you. Government doesn't even have a draft anymore, so you don't have to serve. You can volunteer if you want to. They only ask 2 things for you: pay your taxes and come to jury duty once in a blue moon. So raise your card if you have ever served on a jury. Now, everybody look around at how many people have actually ever served on a jury. So you're not even called up monthly. You're called up once in a blue moon. And this is your service to your country. Thank you. You can lower your cards. Now, the next story I'm going to tell you, and I tell this story because both attorneys want you to answer their questions. They want to get you to know you. Each side is going to have 20 minutes to question you. My friend and I went to law school together. She decided to do civil law. I always wanted to do criminal law. It's always been my passion. So when you do civil law, no offense to the civil attorneys, but usually it's a lot of paperwork. They're not in court every day. So she got called up for jury duty and she said, Stephanie, I've been called up for jury duty. Let's do lunch. I'm like, oh, great. We get together, we're having lunch. I asked her, how is jury selection going? She's like, fabulous. Now that I'm a judge, I think to myself, how could it be fabulous? You're not with Stephanie Boyd in the 187. So she says, it's just like when we were in law school. I'm on the back row. Nobody's going to call me. I'm not going to be on the jury. I start laughing. She's like, what's so funny? I tell her I'm happy because I'm going to get to have lunch with you all week. So other than raising your hand and saying, please place me on this jury, the quickest way to get on a jury is being silent. So I'm going to turn it over to the state. Does anybody need a break before I turn it over to the state? All right. Oh, I'm not going to call your number out. That's okay. All right. So everyone, we're going to come back at 3:40. So before you run to the outside, you are not excused. You have to come back to this courtroom at 3:40. You're going to stand outside. Everyone look to your left and look to your right. It's like paper chase. You're responsible for that person. All right, so we'll be back at 3:40. Make sure you line up and it will make things go quickly if you line up in the order that you're in now. All right, everyone, please rise.
Oh, get the number, you want me high?
Can we leave our stuff in here?
We can.
Yes.
Okay, perfect, thank you. And I'm working on the other files, and I'll give those to you. All right, number one.
All right, Mr. Jury.
Yes. What's the best method to move Calaveras matter?
Okay, great.
Oh, well.
When I get them.
Because mine's always on my bed. All right, everyone, please be seated. All right, State, are you ready to proceed?
Yes, ma'am.
All right, you may proceed.
Thank you. Good afternoon, ladies and gentlemen. I hope everybody had a wonderful Thanksgiving with your family. I know we're here for jury selection, so I'm gonna get straight to it. What is jury selection? I know some of you before have been jurors, others have not. Maybe others have come to jury selection before and haven't been chosen. Maybe this is the first time for some of you here today. So the goal of this proceeding is to select 12 fair and impartial jurors. Okay, this is that process where we're selecting the jurors, and there are two rules that I want to adopt in this case. Okay, rule number one is to be honest in your responses, and rule number two is to be respectful. Okay, the way that we're going to be conducting this is by having an open discussion, and the judge did mention to you all it's about the numbers, so make sure you raise your numbers, and then if you sit on the rows over here, make sure you stand whenever you speak, okay? So let me go ahead and give you an example. Juror number 3. What is the best ice cream flavor in the world?
Chocolate.
Chocolate. Raise your numbers if you agree that chocolate is the best flavor in the world for ice cream. Well, there's not that many people, but thank you. That's essentially how we're gonna be running the show, okay? I'm gonna talk to you all about the law, okay? The charge in this case is a violation of a protective order / bond condition with 2 previous convictions. And here are the elements that I need to prove. The state of Texas, meaning us, have the burden of proof. And I need to tell you when it happened, which is the date, on or about. I need to tell you where it happened, and that is the county in which it occurred, because that gives us the jurisdiction. Number 3, I need to do it if that the defendant, which is the person that is accused, intentionally and knowingly violated a protective order. And by the protective order, I have to tell you which court granted this protective order, which county it was signed, when it was issued, and the cost number of that protective order, and the manner and means is how did the defendant violate this protective order. Those are the elements that I need to prove. Along with, I need to show you what those two prior convictions are for, which is why we're here in a felony court, okay? Normally, a violation is a misdemeanor, but it becomes a felony when two or more convictions have been committed, okay? Notice that there is nothing in there about the why. And I know that a lot of us want to know the motive. Why did this person commit the crime? But that is not an element of the offense that I need to prove. However, you all are free to disagree. Okay, so raise your number, despite knowing what the law requires, which is no motive. Raise your number if you're going to require us to prove the why, the motive. Raise your number if you're going to need to hear the why. Anyone? 59? Okay. 59, 40, 48, 19, 7, 13. Anyone else? And again, I just want to make sure that everybody understands the question. If I prove all the elements that are up here, okay? If I get to prove that, it proves the case, raise your number if you're still going to require me to prove the why. And I think the one, if I already called your name, your number, that's fine. Is there anyone else? Juror number 30, juror number 75, and juror number 3. Okay. We know what the elements are, and we know that there's a trial, but the question is how much evidence is enough? And this is where the burden of proof comes in. And the judge did touch upon a little bit about this. It is a preponderance of the evidence standard on the civil side. So we've all heard these commercials in personal injury, right? The Thomas J. Henry and the 444 guy and the Texas hammer that gives you the justice that you deserve. That is done in the other building that's across, which is in the civil case. And the burden of proof there is preponderance of the evidence, which is 51% or more, or 50.01% or more. So if one side proves the case by 50.1%, then that side is that you should find for that side. So the next burden is clear and convincing evidence, and this is what's done in a termination of parental rights. And then the highest burden is beyond a reasonable doubt, which is what the judge mentioned earlier. There is no definition of beyond a reasonable doubt. But I'll tell you what it's not, and that it's not beyond all doubt. The key word is reasonable. Okay, so I can't tell you what beyond a reasonable doubt is, but I can give you an example. I want you all to imagine that it's a Sunday, early afternoon, and you're going with your family or with your friends to the movies. You park your car and you're walking towards the movie theater, and you start noticing that the sky is getting cloudy and gray. You start noticing a breeze in your face and blowing your hair. You go into the movie theater. You start watching Wicked. You start hearing Glenda and what's the other characters' names? Alphaba, yes. And they start singing really loud. So you're not focusing on the outside, you're obviously focusing on the movie. And when you walk out of the movie theater, when the movie's finished, you see this. Let's see, juror number 5. What happened?
It rained.
It rained. Tell me how you reached that conclusion.
The puddles on the ground.
The puddles on the ground. Juror number 7, what do you think? How else can you reach that conclusion?
It's raining.
Yes, that it rained.
Oh, I didn't see any rain, but it's just wet on the ground.
It's wet in the ground, okay. Let's see, juror number 6.
The puddles on the ground, the wetness on the floor, on the
Okay.
pavement.
What about the cars? Cars are gonna be wet, right? The sky, right? Now, is it possible for the San Antonio Fire Department to get dispatched to the parking lot and give everyone a free car wash? Is it possible?
Yes.
Yes, it's possible.
Yes.
Is it reasonable?
No.
No. Otherwise, the city council will be probably firing the fire chief for using the water there, right? So that's the keyword, right, is I don't have to bring in the fire chief to tell you that they did not respond to give everybody a free car wash. Use your common sense and make that connection. What is reasonable? It's beyond a reasonable doubt, okay? The judge did touch upon a few of these things earlier. These are the defendant's rights. Defendants do have a right to an attorney, trial. I think the most important part that I want to highlight is they have the right to discovery. And that is all the evidence that we have in this case, we have to turn over to the defense, okay? That is my legal obligation. So it will have everything. It doesn't work the other way around, okay? It does not work the other way around. I'm going based on what I have as my evidence. And speaking of evidence, let me tell you what is not evidence, okay? And that is the defendant's criminal history. That's not something that I cannot tell you. Or I cannot mention any of that if there is anything, okay? I also cannot mention also what is not evidence is police reports, which counterintuitive, right? Well, what do you mean police reports are not evidence? Well, because police reports are what we consider as hearsay. The good news is that you will have the officer, the author of the report, take the stand, okay? And of course, we have the police report, so if there's anything that the officer testifies that is not consistent with his own report, trust me, my colleague is going to be the first one that's going to call it, okay? So we have the evidence, but that's not admissible evidence. Also, footage of any prior statements except made by the defendant. That's also hearsay. There are exceptions that may or may not apply, but generally that's the rule. But most importantly, anything that is not before you in the deliberation room is not evidence, okay? If it's not before you in the back, it's not evidence. But what is evidence, obviously anything that gets admitted, most important part is testimony. Witnesses are going to take the stand, they're going to be under oath, okay? We are going to ask questions, and whatever they say, whatever comes out of their mouth, that is evidence that you get to consider. Testimony is evidence. I do want to talk to you all about protective orders. Anyone know what a protective order is? Jury number 39, what's a protective order?
It's a stay away order, so it's an order that's given by a judge to a victim for the other person to stay away from them, whether it be their job, their home, their school, anything like that. They can't go within so many feet.
Yes, that's exactly right, Archie. So a protective order is a document that is issued by the court, signed by a judge, and it prohibits a person from doing certain things. Generally, this is the language of what the court prohibits the person from doing. I know it's very small, so I'm going to go ahead and just read it out loud. One of the most common things is you can't commit family violence. Generally, whenever a protective order gets issued, it's because the person has committed family violence and a judge made the decision that there's a likelihood of future family violence, so I'm going to grant this protective order for the applicant, which in this case, well, it would be the applicant at the time, right? So you can't commit family violence anymore. You're not supposed to. You're not supposed to communicate with this person directly or indirectly. You can't go to or near the residence, place of employment, or school if they're a student. Generally, the language is 200 yards from the location, but that's a prohibition. You also cannot engage in any conduct that is reasonably likely to annoy, harass, embarrass the applicant. You can't have any firearms in your possession, okay, even at home, and removing or harming or threatening a pet. This is what the legislator has ordered. This is what generally a protective order looks like, okay? Now that you know what a protective order prohibits, I do want to ask everybody's input on this question. Which protection provision from the ones that I read is most important to you as an individual, okay? Number one, prohibit communication. Number two, prohibit from going near the residence, employment, or school. prohibiting from possessing a firearm, or prohibiting, removing, harming, or interfering with a pet. I think we all recognize that all four of them are important. That's why they're in the protective order. But if you were to pick one which is the most important to you, okay, raise your number. So those that agree with number one, prohibit communication, raise your number. 1, 2, 4, 11, 22. Those that agree with number two, prohibit going near a residence, raise your number. 3, 5. You do?
Yeah.
8, 9, 10. 5 and 6. 12, 13. If I call your number, you can put it down. 15 through 17, 19 through 21, 24 through 29, 31 to 36, 37, 39, 40, 41. I got it. It's okay. 42, 43, 44 through 50, 51 through 56, 57 through 60, 61, 62, 64, and 65 all the way to 75. Those of you that agree with number 3, raise your number. 12, 14, 18, 30, 38, and 61. Those that agree with number 4, raise your number. 23 and 55. Okay. So generally, just to give you an introduction of the process, a person applies for a protective order either through the Family Justice Center or through an attorney. They go to a court, then an officer goes and serves the respondent, which is the person that is being the protective order sought against. An officer goes and gives them notice and saying, hey, there's going to be a court setting on this day. Are you this person? I'm going to give you this. You've been served. You need to show to court on this particular day. There's a person applying for a protective order against you. If you don't show, there may be a protective order issued without your presence. So the person gets the court setting, and then in the court setting, a court can either one, reset the case to give the person more time to maybe hire an attorney because they're entitled to hire an attorney if they want to, but they're not entitled to an appointed attorney because it is a civil proceeding, not a criminal proceeding. Number 2 is they can agree to the protective order. There are some people that say, you know what? I agree, stay away from her. I'm not going to talk to her anymore. I'll agree. And that's the end of it. There's also people that have a contested hearing, and that is you have the right to argue it. You go in front of a judge and you have the applicant that brings in evidence as to why there's been family violence committed. And then the respondent can also present evidence on his behalf, and then ultimately the judge makes a decision. That's when it becomes contested. Number 4 is a default, and that is the person has been served and he doesn't show. The law says that if you've been given notice and an opportunity to contest it and you don't, a protective order can still be issued against you, right? So that's generally the process, the way it works. Raise your number if you know a person that has been a victim, including yourself, right, of domestic
5
violence.
minutes.
Thanks, Judge. So I think this is a very predominant issue in San Antonio, as you all can see. In criminal cases, why would victims not testify in criminal cases? Can y'all think of reasons why they would not testify? Number 55? Fear. Fear? You're right. Number 1. Anyone else?
Retaliation.
Okay, that was the second
So
one, but yes, definitely retaliation. Anyone else? 33?
Shame or embarrassment.
Okay, yep, it's there. It's 21?
Maybe it's a false allegation.
Okay. And they're afraid that they are gonna be caught on the line? Okay. 65?
Be like a one-time thing, won't happen again.
Yeah, 72.
Afraid that they wouldn't be believed.
Okay. Yes, there's actually several reasons why, which leads me to the next question. Should the state proceed in a criminal case without the victim?
Yes.
So let's ask, everybody's gonna have different opinions, right? Raise your number if you say no. The state should not move forward without the victim in this case, or in any case, actually. Number 54, anyone else? 23, 32, 69. Anyone else? Oh, 3 and 4. 73, Okay, is it fair to say that everyone else agrees with number two?
Yes.
Okay. Police officers, I think the judge, well, let me ask this question. Who has not been pulled over by a police officer in their life? Nice to meet all of you all. You guys are the prime example of drivers in San Antonio. But I do want to ask this question. Has anyone ever had a truly negative experience? And what I mean by negative experience or truly negative experience is not because an officer gave you a traffic ticket. I'm talking because we agree that it's not a good experience either way. I don't think there's anybody that smiles at the officer when you receive the ticket, right? It's not fun, right? But I'm talking about an experience just so profound that you will not believe anything that is coming out from an officer's mouth. Raise your number if you just do not believe anything that police officers will say. Number 38, 45, 44, 47, 55, 35, and 59. Okay, I'm gonna ask the question one more time, okay? Does that experience, so if the officer comes in and testifies, and that officer proves all the elements that I need to prove, is, from those that raise their hand, actually raise your numbers, the ones that I just called earlier, is that experience so profound that you cannot set it aside and find the defendant guilty if the officer proves all the elements of the offense? Raise your, keep your numbers raised if it's just so profound that you cannot set it aside. Okay, 59, 47, 32, 38, 44, 45, and 55.
1 minute.
Okay. I think, because I have 1 minute left, I think I would give you guys back that 1 minute. Thank you.
All right, thank you. All right, defense.
Yes, Your Honor. May it please the court, opposing counsel. Ladies and gentlemen, my name is Michael Collins. I'm a private defense attorney here in San Antonio, Bexar County, Texas, meaning I do not work for the state. I'm in private practice. We get court-appointed cases, we take on retained cases. I'm allowed to practice within the state of Texas. I've been practicing here in Bexar County for about 36 years. Does anyone know me or know of my firm, Collins, and Collins? Okay, thank you. Has anyone had a unfavorable encounter with a defense attorney before? Or you've maybe been represented by someone, or a defense attorney did something wrong to you or something like that, and you just felt you were not treated fairly? Why like that? Does the fact that I'm a court-appointed attorney change your view of the circumstances here? You're thinking, well, a court-appointed attorney won't do as good a job as a hired attorney. Yes, sir. Don't you think? Okay. Anybody else? Yeah, 32. Okay. Is it right? 54. 17. 72. Of those that raised your card, is it because of personal experience? No? 59, 17? No? 54? No? 32?
Yes.
You said yes?
Yes, sir.
You had a bad personal experience?
All right, if you're not on these rows, be sure to stand up.
Yes.
Okay. Or do you care to elicit anything about it? What happened? Or would you like to?
26 years in the court. As a court officer, as a police officer.
Okay. So you've seen some bad experiences?
Yeah.
Okay. Does anyone, just by looking at my client, Mr. Casanova, look at him and say, well, I just don't like the way he looks. He kind of looks guilty. Does anybody think that at this point? Our biases are deep inside of us, you know. I come in thinking Big Red and barbacoa is the Sunday best thing. Okay, that's my bias. Okay, other people would disagree with me, but what do they say? Appearances are the first thing that you think they latch on. Okay, and so when you see somebody for the first time, you make a judgment. You know, you may not know anything about them, but you naturally make a judgment. Okay, you may not act on that judgment. You may keep it in your head. Okay, but then you find out and go through the process. Okay, so my question, like I said, is just saying, when you first When you first saw my client, was there anything about his appearance that made you question whether he's guilty or not? Anybody? I'll put this back on. Now, we have this path that we have to go through, and basically, a defendant is presumed what? Innocent. Right? And you have to go from a presumption of innocence to what? What? Guilty. And how guilty? Not a reasonable doubt, okay? So we go from presumption of innocence to the burden of proof of beyond a reasonable doubt to having been found guilty. So it's a proof problem, and it's the state's proof problem, okay? They're the ones that have to prove something. Defense does not have to prove anything. We're not here to prove anything. They're here to try to prove guilt. And the way they try to prove it is through evidence. The evidence, the only evidence that you can consider is what comes through that witness stand or what the judge allows in as evidence. It may be a document, it may be a video, it may be a person's testimony. That's the evidence. If something's missing, you can't say, well, I don't know, I'm going to still consider it anyway. Can't do that. Now, you are the trier of fact. You put whatever weight into the evidence that you want. If you want to put a lot of evidence into a video, that's your choice. If you want to believe one witness and not another, that's again your choice. Because at the end of the day, if you're on the jury panel of 12, you have to make a determination based solely on the evidence that's been presented to you as to whether the state has taken this case from presumption of innocence to guilt beyond a reasonable doubt. And you, each and every one of you have to make that decision. Now, if you're on the jury of 12 and you're back there and the trial had just finished, the judge sends you back to deliberate, and you're one of the 12 and you've got in your mind, well, you know, I've got a doubt. I've got what I think is a reasonable doubt. You have it, does everyone have the courage to say right now that they'd be able to hold out and keep that stance? Because you're not allowed to just give up your stance and say, well, 11 of you say it is, and I'm saying it, well, I must be wrong. You have a right to hold out. Does everyone understand that? Yes, because it's very important. Why is the burden of proof at beyond a reasonable doubt on a criminal matter? Why? Anybody? Why is it such a high burden? Anybody answer?
Consequences for the defendant.
What's the consequences? Yes. What's he potentially going to lose?
Freedom.
His freedom. Freedom is liberty. And we consider that extremely important. Whereas on the civil side, it's what?
Money.
Well, no, but what is the burden? Preponderance of evidence, right? Just tipping the scales slightly. It's got to have that 50-51 thing because typically it's money. Typically it's something that can be replaced. You're not losing your liberty. Okay. So I'm telling you this because it's something you have to consider very seriously. Okay. You can't just willy-nilly decide, well, what the heck? You know, I'll cave in, what the heck? I'll do this. You have the obligation to make that determination on your own. Has anyone here been a victim or at least a complainant on a protective order case? Your numbers? 62, 72, 20, 19, sorry, 33. Sorry, my eyesight's not the greatest. 17. Anybody else? Of those that raised your cards, was it resolved to your satisfaction? Anybody say no? 20? Was not?
Yes, it was resolved to my satisfaction.
Was not.
It was.
It was. Okay. Any of them other that was not resolved to your satisfaction? Okay. Does anyone disagree with a statement that my client, Richard Casanova, is as innocent of this offense right now as you are? Anyone disagree with that? Next of all, how do you determine whether a person's telling the truth? Anybody? What signs do you look for? Anybody?
Body language.
Yeah, body language.
Body language. Anything else? Speech. Speech. What about nervousness? What about lack of eye contact? What about this? What if, I think the studies have said that something like this, that's a very defensive posture, okay? I don't know what they're defending, but it tends to be, when somebody does like, they're being defensive, okay? Now, whether that means evasive or otherwise, but it is something to consider, okay? And you as jurors, that's what you've got to look at. You've got to determine whether the witnesses are being truthful or dishonest, and whatever weight you want to put in it, because that's what you've got to pay attention to. Does anyone have any physical ailments or anything like that that would prevent them from being on a jury and being able to observe this for hours at a time? Number 38. Anybody else? Now, if at the end of the case, you believe that the state has gotten about 95% of the way, what's your obligation?
Reasonable doubt.
That means there's a reasonable doubt, which means you have an obligation to come back with a not guilty verdict. Does anybody have any problem with that? Say, well, state sure did get close, but I don't want to let this guy go. You understand that you have that obligation to come back with a not guilty verdict? Anybody have a problem with that? No? Thank you for your time. Appreciate it.
All right, ladies and gentlemen, I'm gonna have you all step outside. And then we will call you back in and let you know who has been selected for the jury. You are not excused, and I'm gonna have you all take your items with you, but please leave the cards behind. All right, everyone, please rise for the jurors.